All right, good morning, everyone. I hope you all took some time to get some more coffee because I'm sure you guys know that this tax stuff can be really, really interesting. Over the next 50 minutes, we're going to be talking about the Secure Act. We're gonna talk about a lot of the different changes that the Secure Act brought on, but we're really going to focus on the effects that the Secure Act has on the beneficiaries that inherit IRAs from their parents for the most part. And we're also going to talk about the Secure Act from the perspective of elder law, from our perspective, what a lot of what we're seeing. So like Kyle said, my name's Jenna Franks. I'm one of the attorneys from Steinbacher, Goodall, and Yurchak. I actually work primarily out of our state college office. Just to give you a little bit of background on me, this is my husband, Josh, our daughter, Ava, who's 10, and this is our new son, Grayson. He's 7 months old. And actually, Ava's doing virtual schooling and both kids are home most days. So between the two kids and the dog, my house basically sounds like a zoo most days. I'm sure some of you can relate to that. So that's great. Now, the practice areas that I focus on are estate planning, long-term care planning, and special needs planning. And just to give you, just to kind of lighten the mood a little bit, because this tax stuff can get a little, it can really bog you down. Here's a little comic for you. It just says, and I'm sure I can trust you not to fight over my money when I'm gone. That's probably the father here. And each kid says, of course, and they have their weapons ready to go. So I'm sure a lot of you can relate to an experience similar to this. It just kind of happens, unfortunately, in our line of business. So let's start talking about the Secure Act. So some of the big changes that have happened with the Secure Act is now you can start taking required minimum distributions at the age of 72. So it used to be once you reach the age 70 and a half, which I'm not sure where they came up with the 70 and a half, but it was 70 and a half, you had to start pulling required minimum distributions. Now you don't have to take those until the age of 72. And before the Secure Act, you also were not able to contribute to your IRA once you hit age 70 and a half. Now there's no age cap on when you can make those contributions to your IRA. So you can continue making contributions to your IRA even after the age of 70 and a half, and there is no age cap on that. And additionally, long-term part-time employees can enroll in a company's 401k. So those are some of the changes. But like I said, the big change that we're going to focus on throughout most of this presentation is inherited IRAs and what happens to the beneficiaries that receive those. Now, the Secure Act, as far as this is concerned, really affects deaths after 2019. So anything 2020 and after, this is really what's going to affect. And previously, before the Secure Act, most of you probably know this, an inherited IRA, the beneficiary could receive the stretch out over their life expectancy. Okay, that used to be the rule. Now, the default rule is that an inherited IRA must be withdrawn within 10 years. Okay, so big change there. There's actually a 5-year rule. If the beneficiary is considered a non-designated beneficiary, then the IRA must be withdrawn within 5 years. That would be like an estate or a non-designated beneficiary trust. We don't see those quite as often. For the most part, what we see is the 10-year rule. The IRAs must be withdrawn within 10 years. Now, there is an exception to this. For beneficiaries that are considered eligible designated beneficiaries, they can actually continue to receive the stretch out over their lifetime. Okay. Now, these are the different categories that are considered eligible designated beneficiaries. So surviving spouse. A surviving spouse is always going to be considered an eligible designated beneficiary. So it's not the surviving spouses that we're really concerned about when it comes to the taxation of these IRAs. The spouse is fine. It's the next generations that we're really concerned about and the income taxes that they'll be stuck with, basically. There's also a minor child. And they can receive the stretch out over their life expectancy, but we really call this life expectancy modified. So as long as the child's under the age of 18, they're considered a minor child. But if they're in some sort of education, whether it's college or trade school, they can actually continue to be considered a minor child up to the age of 26. Now, as soon as they're no longer in education, or as soon as they hit age 26, they're no longer considered a minor child. And so then the 10-year rule starts. So it's no longer the life expectancy. So that's why we say it's life expectancy modified. Basically, life expectancy until they reach either age 18 or they're in some sort of schooling and they hit age 26. Then it's the 10-year rule. The disabled individual, believe it or not, the definition of a disabled individual under the Secure Act guidelines is more restrictive than the Social Security guidelines. Now, in practice, we really don't anticipate an issue if you have a client that is disabled under the Social Security guidelines. That will likely be enough for them to be considered disabled under the Secure Act guidelines. Now, we're not positive on that yet, but that's kind of what we anticipate. You will have to provide proof of the disability, but once you do that, then the disabled individual can receive the stretch out over their life expectancy. And we'll kind of talk a little bit more about that here in a little bit. There's also the chronically ill individual. This would be someone who needs care, whether that's in a nursing home or an assisted living facility. They could receive the stretch out over their life expectancy. Now, this is the type of client that we would probably look a little more closely at, though, because if they're receiving care or they're in one of these facilities, chances are they might need that money, or it might make more sense for them to use the IRA money to pay for their care. There would be offsetting medical expenses. So a lot of times we might want to use those IRA funds to pay for the care for that chronically ill individual. This is just one of those situations where you want to spend a little more time trying to figure out what's going to work for the client. And then there's also the individual not more than 10 years younger than the employee. So this would be maybe a sibling or a partner or a friend, but the person cannot be more than 10 years younger than the employee. Okay, so those are the 5 different categories of an eligible designated beneficiary. Like I said, if you fall into one of those 5 categories, then you should receive the life expectancy or the stretch out over your life expectancy as long as you maintain that category. Otherwise, it's going to be the default 10-year rule. The IRA has to be withdrawn within 10 years. Okay. Now let's talk a little bit about the Secure Act from an elder law perspective. I'm going to go through each of the different types of clients that we see and what we found as far as the Secure Act. First of all, we're going to talk about estate administration. What we've done a lot and you probably know, these are clients that have passed away. A lot of times what we're seeing or looking at are whether or not partial disclaimers work in these situations. So what I'm talking about is you have a married couple with children and one of the spouses pass away. Now, typically, the deceased spouse's IRAs would go to the surviving spouse. What we look at is, does it make sense to disclaim some of that IRA money from going to the surviving spouse and instead have it go to the children? Not all of the IRA money, just some of it. Basically, what you're doing at that point in time is you're creating 2 10-year time periods for the children. So you're starting a 10-year time period for the part that's going to the children now, and then you'll have a second 10-year time period when the children receive from the surviving spouse. So it kind of breaks things up a little bit. This really requires a discussion. I mean, first and foremost, we want to talk to the surviving spouse and see if they're going to need those funds. Because if the surviving spouse needs the IRA money to live off of, well, then it doesn't make sense to even have the discussion about how the money goes to the kids because the spouse needs the money. We also want to look at the inheritance taxes involved and make sure that those benefit all parties. Excuse me. And then lastly, we want to watch gifting for Medicaid purposes. So if the surviving spouse needs care, or if you anticipate they might need care in the near future, we want to watch making these disclaimers. Because when you disclaim money from going to the surviving spouse and instead have it go to the children, that's seen as a gift for Medicaid purposes. And basically, if the surviving spouse needs Medicaid at some point in time, making this disclaimer could disqualify them from Medicaid. So we definitely want to watch that as well. So that's just another concern. So again, it really just requires a discussion with the client, maybe the family, to figure out, what the goals are and what's going to work in this situation. Long-term care planning clients. These are clients that are typically concerned about needing long-term care, or they're concerned about how they're going to pay for that care. What we've found as far as the Secure Act goes is really the Secure Act hasn't affected these clients quite so much as many of our other clients. The average long-term care client usually has around, they have a house and maybe $500,000 just on average. They might have an IRA worth $100,000 or $200,000. So what that looks like in a family that has 2 kids, if the parents pass away, and there's a $200,000 IRA going to the kids. So if we have a $200,000 IRA that's being split between the 2 children, basically they're each going to have to take about $10,000 over the 10-year time period, $10,000 per year. I mean, in the grand scheme of things, I really don't think that affects most of these beneficiaries as overwhelmingly as some of the other situations where clients have a lot more money and we're really pushing up these beneficiaries to higher tax brackets. And what we also find is a lot of times the beneficiaries receiving, maybe $100,000 or $200,000, a lot of times they use that money. They're not even letting it sit there, So the Secure Act just doesn't seem to be affecting these long-term care planning clients quite as much as many of our other clients. Now, our clients involved that are special needs planning clients. This would be families, typically like married couples with maybe 1 or multiple children, and at least one of the children has some sort of special need, or they're on government disability for some reason. That's typically what we call a special needs planning family. Keep in mind, if the child with special needs is disabled, they should qualify as an eligible designated beneficiary, and they'll receive that stretch out. Now, it's really always been beneficial to have IRA money go to children on disability versus the other children that are not on disability, because typically the child that's on disability benefits is in a lower income tax bracket. Now, you have to watch, because if you have more income going directly to the child on government benefits, you could risk kicking them off government benefits because they're receiving too much income. But there are ways to use trusts or to have the money used to their benefit without giving them the actual money themselves. And there's good tax strategies to be able to do that. So our average special needs planning family it's 2 parents, maybe they have 3 kids. One of the children has some sort of special needs. They need government benefits, Social Security, SSI, and maybe Medicaid benefits. We have to sit down with these clients and really talk this through. Some clients are very interested in making sure that child with special needs is provided for throughout their life. They're not necessarily concerned about making things equal across the board for all 3 kids. They really just, a lot of times the kids that don't have special needs, they're able to provide for themselves. They really want to make sure that child with special needs is taken care of, in the long run. But other clients have different perspectives on this. They want to make sure that everything's equal, regardless of what that looks like for each child. And there's no right or wrong to this. We just have to figure out, what the client's goals are and how that might look. And even if they want everything to go equal between the children, it still might make sense to have more of the IRA money go to the special needs, the child with special needs. So like I said, it's always been beneficial to have IRAs go to the children that are receiving government benefits because they're in a lower tax bracket. Well, it's even more true now because they can receive the stretch out over their life expectancy. So it's just something else you really want to maybe spend some more time on to see if this makes more sense for these types of clients. And we're going to talk about accumulation trusts here shortly, but it might also make sense to possibly use an accumulation trust in this type of a situation. The next type of client we're going to talk about is a wealth protection planning client. These in our office, these are the clients that typically have at least $2 million. So a lot of times the focus, we still want to have discussions with these clients about paying for long-term care, but a lot more often our discussion is focused more on trying to avoid paying too much in taxes, paying unnecessary taxes. So that's really the focus on with these clients. And really, these are the clients that are probably most affected by the Secure Act because they have more money in IRAs. We used to oftentimes have IRAs go to the grandchildren, to receive the stretch out over the grandchildren's lifetime. Unfortunately, grandchildren are still stuck with that 10-year time period. So this really doesn't add any sort of a benefit at this point. That really doesn't solve any problems for us. The big issue with the Secure Act, I'm sure you guys have already picked up on this, the big issue with the Secure Act is once the IRA money goes to the next generation, well, now they have to withdraw that within 10 years. And all that income is going straight to, all that income has to be taxed. And so we're pushing these beneficiaries into much higher tax brackets in a lot of situations. And we're actually going to look at some case studies to kind of look at how drastic sometimes this can be. But that's the big issue. And sometimes we need to pull those beneficiaries into the conversation to see, if there are better options for them. Maybe there's a way to get, maybe it won't be such an issue for beneficiaries that are already in a high tax bracket. But, if they're not in a high tax bracket, then we might want to look at other options. Really, what we want to do is, as an attorney and as a professional, we want to work with financial advisors, accountants, and other attorneys to really find the best tax situation for the clients that still meets their goals. But at the end of the day, sometimes it just makes sense that the taxes are paid. And you're going to find that in some situations. It's just we want to make sure that that's still the best option for them. Okay. So let's look now at some of the different trusts that we've used previously for retirement trust planning, and how those have changed since the Secure Act is in place. So the conduit trust, this is really, you can kind of see this as a flow-through trust. So any RMDs that the trustee takes from the IRA plan must be paid to the beneficiary. So you can see here in the picture, if the trustee pulls an RMD of $50,901, then the RMD has to be distributed to the beneficiary, same amount. So it's just a flow-through trust. And prior to the Secure Act, we actually used the life expectancy of a single beneficiary to receive that stretch out. Okay. Now, because of the Secure Act, we're limited to the 10-year default rule. Now, if the beneficiary of the trust is considered an eligible designated beneficiary, then we still can receive we still can use the life expectancy of that beneficiary. But otherwise, we do have to distribute within 10 years. Now, a conduit trust for the spouse does still work, but a conduit for the children could really cause some major tax issues, especially in year 10. Now, the next trust is an accumulation trust. So this is a trust where basically the trustee has discretion to either hold the RMDs in the accumulation trust once they're pulled from the IRA, or the trustee can pay some of that money to the beneficiary. So the trustee has more discretion here. prior to the Secure Act, we used the life expectancy of the oldest beneficiary. Now, again, we are limited to that 10-year default rule. But if your beneficiary is an eligible designated beneficiary, then we can use the stretch out. So the potential problem with this trust is that if the trustee decides to hold some of the RMDs inside the trust and not pay those to the beneficiary, well, then those funds within the trust are going to be taxed at the trust income tax rate. Just to give you an idea of what we're looking at, trust income tax rates are not beneficial in those situations. They're very high. So if the trust income is over $12,950, which is not very high, you're already at that 37% bracket. So this really requires, again, a discussion on whether it makes sense to have that money funnel straight through to the beneficiary, or if you want to withhold some of that money inside the trust, subject to that 37% tax rate. So in some of these situations, there's really, there's no great option, but definitely things that you want to keep in mind. The next trust is the Charitable Remainder Trust. This is a trust that's designed to reduce the taxable income of individuals by first dispersing the income to beneficiaries of the trust for a certain period of time, and then donating the remainder of the trust assets to a designated beneficiary. So this could really be beneficial for some cases. A charitable remainder trust does not pay federal taxes on IRA distributions or growth of assets within the charitable remainder trust. Now, you can actually set this up so that the beneficiary is receiving a fixed amount or they're receiving a percentage. So here is a picture on here that kind of shows you, you have an IRA of $1 million, and then you transfer that into a charitable remainder. You set up the charitable remainder trust so that a percentage of the trust goes to the child for their lifetime. And then once the child would pass away, the remainder goes to that designated charity. Okay, so this can really save money as far as income taxes go. And actually, if you set this up so that a percentage goes to the beneficiary over their lifetime, it actually works very similar to the way required minimum distributions would work prior to the Secure Act. So that might be one good option. In order to figure out whether this will actually work for your client, you definitely want to look at the different options available. But if you do have a client with, or a beneficiary that's at a good age and they'll be receiving a decent percentage, this really could be a great option to avoid some of those income taxes. So why are we here? What was the purpose of the Secure Act in the first place? Well, really, the whole purpose of this is it's the government's attempt to collect taxes or collect money on the transfer of wealth. So I'm sure all of you know that the federal estate exemption or exclusion was increased to almost $11 million per person. Well, the money that we would have generated if that exclusion was lower, I mean, we have to come up with it somewhere. And so now this is the government's way of bringing in more taxes, but we're taxing more from income tax. It's actually projected that the Secure Act will bring in about $15 billion in revenue in the first 10 years. So, I mean, they're really and if you actually look beyond the 10 years, it's a crazy amount of money that this is projected to bring in. And you can, once we kind of look at the case studies, you'll probably see why, there's so much money that this is projected to bring in. Overall, the Secure Act is going to require more of a sit down, and it's really going to, I think it would be most beneficial to sit down with the clients, with the advisors, with the accountants, with, if there's other attorneys involved, and really figure out what options are there for the clients and what option might work best for these clients. This type of planning is not a one size fits all. We're really looking, we're obviously looking at the amount of assets the clients have. We're looking at what their assets look like. We need to look at their family structure, who their beneficiaries are, what their health looks like. There's so many different factors for each client that we really have to sit down and take the time to look into these files. I mean, we may even have to involve other family members if the clients are open to it. You know, a lot of the consequences of the Secure Act are really going to affect the beneficiaries, in a lot of cases, the children, right? So it might make sense to include the children in these conversations, you know, again, if the clients are open to it, just to make sure that we're not, you know, causing any undue harm to the children, you know, because a lot of these parents wouldn't want that to happen at the end of the day anyways. Now, one option that's come up more often is Roth conversions. Now, in some situations, these do seem like a good idea. A couple things to keep in mind when it comes to the Roth conversions. You know, the goal of converting a traditional IRA into a Roth IRA is to mitigate the income tax costs by parents paying some income tax now so that the future distributions to the children are not subject to that 10-year rule. So basically, by paying income tax now, you're saving your children or your beneficiaries taxes later on, you know, while things are still growing within the Roth IRA. Additional things that you want to keep in mind is the conversion to a Roth could make Social Security for our clients taxable within the next year. So that's something that you definitely want to look at. Their Medicare premiums could go up. In a lot of cases, you know, these Medicare premiums start a little over $100. They can actually go up to almost $500 a month. And from what we've seen, for some reason, clients do not like to see their Medicare premiums go up. So something to keep in mind. And what we've also found is that higher incomes tend to benefit most from the Roth conversions. You know, again, it's not across the board, but for some reason, for the higher incomes do tend to benefit most from those types of conversions. Now, in reviewing whether to spread out the Roth over time or convert it all at once, you know, we've spent some time trying to figure out what makes the most sense. And again, we have some case studies that we're going to look at, you know, to figure out what makes more sense. What we see in most cases is it makes more sense just to do the conversion all at once. Don't spread it out over a couple of years. And so we'll look at those numbers and talk through that a little bit. So in case study number 1, here the parents have passed away with a $4 million IRA. There's 2 kids, and each kid is set to get $2 million. Kid 1 is 30 years old and makes $30,000 per year. Kid 2 is 35 years old and makes $125,000 per year. So a little bit, not so much of a difference between ages, but definitely a difference as far as income goes. So what that looks like before the Secure Act, the 10-year cost before the Secure Act, we'd be looking at about $148,000 is what it would have cost the child for the first 10 years. Now, if you look directly across from that after the Secure Act, the 10-year cost is going to be a little over $800,000. So this is for the child whose income was $30,000. Okay, so they started, if you look towards the bottom of this slide, they started at a 12% tax bracket. Now, before the Secure Act, those required minimum distributions would have bumped them up to a 22% tax rate. You know, it's not beneficial, but if you actually look after the Secure Act, they're bumped up from a 12% tax rate to a 35% tax rate for the first 10 years. I mean, because it makes their annual income almost $230,000. So a pretty drastic difference here. You know, even if you're looking at before the Secure Act, even over 50 years, it didn't cost them $800,000, you know, to pull out these required minimum distributions over 50 years. So within 10 years to have that up over 800,000, you know, these are the clients that we're really concerned about. Is It's such a drastic change to go from a 12% tax rate to a 35% tax rate. And the costs involved in this are really, really great. Now, if you look at kid 2, this is the child who their annual income was $125,000. Now, obviously, it's still not beneficial for these kids that have higher income, because the 10-year cost before the Secure Act is $531,000. The 10-year cost after the Secure Act is $1.1 million. But if you look at the percentage increase, I mean, kid 2 is really, their 10-year cost has really just doubled. If you look at kid 1, I mean, it's over quadrupled. So that's why we're most concerned about these children that are currently in lower tax brackets, and all of a sudden they're pushed up to those higher tax brackets. So with kid 2, he goes from a 24% tax rate to a 32% tax rate before the Secure Act. And then after the Secure Act, he'd go from 24% to 35%. So again, like I said, it's still not necessarily beneficial after the Secure Act, but these beneficiaries that already receive a higher income are already in a higher percentage, a higher tax bracket. So it doesn't seem to affect them quite as much. There's still a lot of money being lost here, but not quite as drastic as kid 2. So let's say the parents didn't pass away, but they make $7,000 a year, and they want to convert that $4 million IRA to a Roth IRA, and they currently receive $17,000 in security benefits. Well, should we do the 8-year conversion or the 1-year conversion? Now, if you're doing the 8-year conversion, you're converting about $500,000 per year. The one-year conversion, $4 million in 1 year. So if you look at the 8-year cost, if under the 8-year conversion, the 8-year cost, $1.57 million, okay, versus the 1-year cost, and under the 1-year conversion, it's actually a little bit less, $1.5 million. That's partially because if you do this over a period of 8 years, well, your Medicare premium per year is now going to jump up because you're at that rate of about $500 a month. And that ends up being $5,552 premium per year just in Medicare, and you have that for 8 years now. And then you also have the Social Security tax, $14,000, and you're at the 35% tax rate for 8 years. So all that starts really adding up. Versus the 1-year conversion, you're at a 37% tax rate for just that first year, but it's just that first year. And then you're back down to 10% after that first year. You had the higher Medicare premium of $5,000, almost $5,900 for just the first year, but then after that, it's back down to $1,735, okay? And you also have that Social Security tax, but again, it's just that 1 year. And then everything's done, everything's been converted. And it actually, like I said, from what we've seen, it actually ends up saving you a little bit of money, converting everything all at once. Let's look at this as if we only transferred half, or we only converted half of the IRA. So what we're looking at is either a 4-year conversion of $500,000 per year or a 1-year conversion of $2 million that year. Again, we tend to see the same thing. So the 1-year cost in the 1-year conversion is a little bit lower than the 4-year cost of the 4-year conversion. Same thing. So 4-year conversion, you're at a 35% tax rate, but you still have that high Medicare premiums, and you still have the Social Security tax for all 4 years. Whereas if you do the 1-year conversion, you're at a 37% tax rate for that 1 year, then you're back down to a 10% tax bracket. Then you have the Medicare premium for that first year, but then it goes back down to about $1,700 a year after that first year. And then you only have the Social Security tax for the first year. So whether you convert half of the IRA or whether you convert the whole IRA, we're kind of seeing the same, we're seeing it consistently. You know, it typically makes more sense to convert to convert the amount of money right away versus spreading that out over time. Let's look at a second case study. Let's jump that money up to about $8 million. Rather than the $4 million, they pass away with an $8 million IRA. Kids are the same. First kid has makes $30,000 per year. Kid 2 makes $125,000 per year. I'll be honest with you, we're pretty much seeing the same thing, regardless of whether it's a $4 million IRA or an $8 million IRA. So before the Secure Act, the 10-year cost for the child who only makes $30,000 per year, 10 years before the Secure Act, they're spending about $252,000. Now, within 10 years, they're spending $1.5 million. So again, a drastic increase in the cost for beneficiaries in lower tax brackets. Kid 2, again, the numbers are not beneficial to children that have higher incomes, but we definitely don't see quite as much of a cost jump for these types of beneficiaries versus, kids like kid number 1 that we just mentioned. So same kind of thing here. And then here's another Roth conversion case study for you. Same thing, parents make $7,000 per year, but now they want to convert an $8 million IRA to a Roth IRA, and they receive $17,000 in Social Security benefits. So if we're converting over 8 years, $1 million per year, or a 1-year conversion of $8 million, okay? So the 8-year cost for the 8-year conversion is $3.1 million. The 1-year cost for the 1-year conversion is $2.9 million. So again, you're saving some money there. I mean, all this information is basically the same. For the 8-year conversion, you're looking at higher Medicare premiums, you're looking at that Social Security tax, and a higher tax bracket for 8 years versus the 1-year conversion. You have the higher tax rate for just 1 year, you have the higher Medicare premium for just 1 year, and then you have the higher Social Security tax for just 1 year. After that 1 year, everything goes back down. So just still seems to kind of make sense. Again, here's another case study as far as converting only half the IRA. Most of this information is consistent across the board. So we find the same thing. Whether you convert half of the IRA or the whole IRA, it typically makes sense to do it all at once. So let's talk now about some other tools that can be used to help as far as the Secure Act goes. We've already talked about Roth conversions. We've talked about partial disclaimers by the spouse. And we've talked about charitable remainder trusts. All those could be good, viable options. You just really want to look into them and make sure that they make sense. What about life insurance? We always used, or a lot of times we would use life insurance before the Secure Act to kind of offset some of the income taxes, especially in federal estates. Well, it might make even more sense now. The death benefits from life insurance are income tax free. So it might make sense to start looking at purchasing new policies or repurposing old life insurance policies to replace some of the income taxes that will now have to be paid. Like I said, we did this a lot in the past. It might make even more sense to do this again now. From what we've seen though, to be honest with you all, people aren't necessarily running to set up these plans at this point. And part of that is probably because the Secure Act offers tax consequences over 10 years. It's not like the federal estate tax where within 9 months of somebody passing away, all of a sudden you have 40% going to the federal government and you have to hurry up and replace that income. This is more of a tax consequence over time. And so clients aren't necessarily jumping to fix this necessarily at this point. So life insurance is still a good option, maybe even more so now, but I don't anticipate that clients are going to be running to open these policies just to get around the income taxes that now have to be paid under the Secure Act. Something else that might be a good option, and from an elder law perspective, we really like these options, are converting some of the IRA money into either long-term care insurance or into a life insurance policy that has a long-term care rider, something that offers a way to leverage what you have and give you more options in the long run, options to pay for care, because that's always a concern that we have. Believe it or not, right now for our clients that are age 60, it's projected that once they reach nursing home age, which is age 83, that the average cost of care monthly will be up to about $25,000. So that's in just, another 20 years. They're anticipating that the average monthly cost of care will jump from about $10,000 to $25,000 a month, which is pretty crazy. So a lot of our clients that think they've built up a nice nest egg, they might not have quite as much money as what they think, especially at that point in time. So we really like what we call hybrid policies, that offer our clients more options. Hybrid policy is just a mixture of life insurance with long-term care aspects to it. So, they can receive the life insurance benefits if they don't need care, but if they do need care, the option's there. It gives our clients more ability to have that flexibility if they need it. There's also the Pension Protection Act, which allows us to take an annuity and basically put it into a Pension Protection Act annuity. And then the clients can withdraw money to pay for their long-term care. And there are some great income tax benefits to doing so. Overall, we have a lot of different options when it comes to the Secure Act. But what it really comes down to, and I'm sure you're probably tired of me saying this at this point, it really comes down to us slowing down and taking the time to look into these files to figure out what is the best option. What are our clients' goals and what is going to best suit them tax-wise. If you personally have a client, that you just kind of want to bounce some ideas off of someone, or if you really want to look at some additional options that you think our office can help with, you're more than welcome to reach out to us and see if there's any assistance that we can offer. I wouldn't necessarily say that we're experts at this point, because the Secure Act is really less than a year old. So there's still a lot that we're learning in our office as well, but we really like to work with other professionals, accountants, advisors, attorneys, to try to figure out what options are out there and what we can make work. It's really important that we work together to come up with the best option.